Thanks for your time. We appreciate it. So the ruling party's rules and guidelines are pretty clear, but is there any room for a challenge here? Because that's what Ace Magashule is doing.
The only challenge that he can make is to a court of law outside of the ANC. The ANC constitution provides for an appeal, but the highest forum for an appeal is the NEC itself, and that's the forum that has decided to suspend him. So no, there are no further appeals within the structures of the ANC.
He also says that proper process wasn't followed in terms of who suspended him. He says his deputy, Jesse Duarte, could not have signed off on that letter on behalf of the NWC. Any grounds there?
I don't think so. That's going to depend on the minutiae of their rules as opposed to their constitution. But the constitution as it stands, as amended in 2017, gives the Secretary-General the job of passing on a notice of suspension. Now, if it's the Secretary-General himself who's being suspended, it makes perfect sense that it's the Deputy Secretary-General that would do that job. In any event, if he were to try appeal, that would have to be in a court. I don't think his chances are very good.
Yeah. And let's talk about the way in which the ANC has handled this matter. Of course, it's been a bone of contention within the party for a long time. The party agreed on this. They had a resolution on it a couple of years ago, but it was challenged. Specific points were challenged. They eventually went back to branches, then the NEC, NWC, etc. Have they followed all of their own internal processes to get this right?
Now, that I can't comment on simply because I don't know what the sub-rules are that the ANC as an organization has written to give effect to its own constitution. But the constitution is fairly detailed in this respect. It provides for the obvious things like the right of reply, what we'd call audiatum partem in administrative law. So the person implicated, the person who's going to be suspended, must get a chance to respond to the accusations. It follows the Constitution sets out the normal procedure one would expect. I imagine that the rules simply flesh out the Constitution. I don't know what, say, the time periods were that people were given to respond to accusations at various levels, at branch levels, at provincial levels, and so on. So there may be some suspensions that can be challenged, taken on review, but as a concept, that the NEC should make a decision that those facing criminal charges should step aside, and failing which they'd be suspended. That's a perfectly acceptable decision for the NEC to take in light of the ANC constitution.
And then, of course, as you mentioned, Cathy, he can go the legal route, go to court to challenge this decision and argue that, you know, the principle of our constitution as well says that you are innocent until proven otherwise, yet the party is taking such drastic steps against members facing charges.
You know, that's a popular phrase these days, innocent until proven guilty, and it's been completely misused because the provision for suspension of an employee from work or of a member of a party from that party does not require a conviction, and it's not even necessarily a statement that the person is guilty. It's a statement that the person's continued presence at work or in the party poses a risk to the workplace or the party. That's all. And it's a very common practice in all environments where you get groups of people working together.
Yeah. And what would a court consider before agreeing to actually hear this case? Because when it comes to party politics, there are certain things that are taken into consideration, isn't it?
I would approach the question simply from the matter of administrative law. I am not aware of any special considerations that come in when we're dealing with a political party. Perhaps judges would try to persuade the litigants to sort it out themselves. But generally, what an administrative review is going to involve is checking whether the procedure that was followed was fair and whether it was the one that had been set out in the rules and whether the person who took the decision was empowered by the rules of that organization to take the decision. And that's the same inquiry that you would run for any organization. You'd run it for a jockey club, you'd run it for a golfing association. I don't think the fact that you're dealing with a political party should make such a big difference.
All right. Thank you so much for your insights. Appreciate it. Cathy Powell, Associate Professor of Public Law at UCT.